Judge James Boasberg, the chief judge here in Washington, one who has been criticized vitriolically by President Trump, wanted to get some answers. Why weren't those flights turned around as ordered on March 15th? This is so much bigger now than just those Venezuelan nationals. This is now a matter of, are my orders being listened to by the executive branch? Because if not, we got a much bigger problem than just deportations. He didn't like the answers he got today, didn't think they were declarative or clear enough. So he said in so many words, we could be talking about contempt of court in the coming days over somebody or some people inside the administration who haven't told me why those planes didn't turn around. What answers was he given today? Largely, the Department of Justice attorney was saying some of this falls under attorney-client privilege and that he can't answer as to what the administration was saying. But the judge didn't accept that. He wants to know whose name is on this decision to disregard an order of the court on a flight March 15th.
Now, if I recall, Scott, correct me if I'm wrong, earlier when there were legal jousting about this, the administration said, well, it was a verbal order, and a verbal order didn't have the weight of a written order. And by the time the written order was, the planes were practically in El Salvador, so it was...
What's up, guys? You're tuned into Dr. John. A federal judge has warned that specific senior Trump officials could face prison for criminal contempt of court, not Trump himself, but the lieutenants carrying out deportation enforcement orders. The threat escalates the legal conflict between the administration and the judiciary. Judge James Boasberg looked at what the Trump administration did, deporting more than 200 people to El Salvador, using a wartime law that he had explicitly told them they could not use. And he used a specific word to describe it: willful disregard. Not mistake, not misunderstanding, not administrative error. Willful, deliberate, intentional. And then he gave them a 1-week deadline to bring themselves into compliance or face criminal contempt proceedings that he specifically said could lead to imprisonment.
Not relevant to us. Did that come up? Was that still a thing?
That was not an argument that was articulated in court today. It was made in filings previous. Didn't fly. That's why they had to have a hearing today. He wants some better information.
Right.
I mean, the order of the court is when the judge gives the order, it takes effect. The written version sometimes takes a long time to populate, so we don't wait just for.
And it's not a common understanding that verbal orders don't matter, only the written ones.
That's right. And
so we've moved beyond that.
That's not the issue now.
Okay.
The issue now.
And when you say the phrase contempt, what does that mean? It sounds heavy.
Well, it can be. I mean, a contempt of court can metastasize into some type of criminal case. It can metastasize into some type of disciplinary case in the court. They'll be putting the cart in front of the horse now, because the people who signed their names to these court filings are the Attorney General herself, Pam Bondi, her chief of staff, her deputy, her number 3. These are the top-rung officials at the Department of Justice. Seems very provocative to have a contempt finding against them. So we'll see what the judge orders. That order won't come till next week. But there's a fundamental issue here. Outside of the arguments today, the judge actually wanted to know, did you understand me?
That is a federal judge threatening to put Trump's senior officials in jail. Let me walk you through every piece of this right now, because this is genuinely unprecedented in modern American history. Let us be completely honest about what the ruling does and does not guarantee. The headline says, the ruling guarantees Trump's arrest, but let us be precise. Boasberg's ruling does not guarantee the arrest of Trump himself. Presidential immunity, both in the constitutional sense and in the practical sense of Department of Justice policy against prosecuting a sitting president, protects Trump personally from the criminal contempt consequences the ruling is threatening. What the ruling does threaten is the arrest and imprisonment of the senior officials who carried out the deportations in defiance of the court's order.
When I was speaking these orders, did you understand what I meant? And one of the most illustrative lines of questioning, Major, the judge said, did you understand me to say you had to release these people from jail? Did you understand me to say that you can't still deport them through the normal proceedings? And the Department of Justice attorney said, no, we didn't understand that. The judge counterpunched, Major. Well, those who are saying so are mistaken. Clearly, that's been part of the political rhetoric ever since.
So what's happening in the courtroom adheres to a set of facts, even if they're uncomfortable for the administration, that is not being reflected in the political rhetoric being thrown around this entire conversation.
Where have we seen that before? It feels like the 2020 election legal arguments, doesn't it?
Right.
That there's a political argument being made, but when you get called before a judge, you say something a little softer or a little more elegant, not quite what you're saying politically.
And what are at least nominally defensible facts in court,
yeah,
which is where they should be heard and adjudicated.
Not Trump, but his people, the lieutenants, the people who were in the chain of command between the president's policy preferences and the actual deportation flights that took off despite the court order. And that specific threat, criminal contempt leading to potential imprisonment for the officials rather than for Trump himself, is what makes this ruling so significant and so politically consequential. Because it creates a situation where Trump's inner circle has to choose between following his orders and avoiding jail, between loyalty to the president and compliance with the courts, between doing what the administration wants and avoiding personal criminal exposure. That choice forced on Trump's officials by a federal judge is genuinely unprecedented in the modern era of American executive-judicial relations. Now let us understand exactly what happened in this case.
The administration is set to face off in court with the judge that Trump has threatened with impeachment if he doesn't sign off on Trump's immigration crackdown. Justice Department attorneys will go before federal judge James Boasberg and argue that the Trump administration did not violate his orders when they used the Alien Enemies Act to deport accused Venezuelan gang members to El Salvador. This hearing could lead to an unprecedented showdown between the president and the judiciary. Let's bring in our reporter, Alex Mallon, for more. So let's talk about what's at stake here.
Yeah, Kira, the hearing is already underway, and you can already tell by this questioning from District Judge James Boasberg that he pretty much has already made up his mind that the administration did indeed violate this temporary restraining order that he put in place on March 15th. You remember that was that Saturday where all of a sudden the administration announced that it was invoking the Alien Enemies Act to deport 2 planes full of over 200 alleged gang members of the Tren de Aragua gang and send them to a max security prison in El Salvador. Basically, there was a hearing that day on March 15th where Judge Boasberg ordered the government orally saying,
the Trump administration has been aggressively using the Alien Enemies Act of 1798 to deport migrants. It characterizes as members of the Venezuelan gang Tren de Aragua. We covered the Supreme Court's emergency orders blocking those deportations in earlier videos. Judge Boasberg was specifically involved in the litigation over the administration's use of the Alien Enemies Act. He issued an order specifically prohibiting the administration from using that wartime statute to deport certain categories of migrants without due process.
That if there are planes in the air right at this moment carrying people that are being deported under the Alien Enemies Act, you need to turn those planes around right now. The administration maintains that they did not violate a later written order that was put in by Judge Boasberg, but he is trying to nail down whether they violated that specific verbal order that he gave during that hearing. And right now, he's grilling this attorney during this hearing in D.C. He basically has already said to them that he believes that the government acted in faith that day by this rushed job to basically deport that scores of alleged gang members who he said that did not appear to have any due process before they were deported out of the country to a foreign jail where obviously they have faced and the administration has really broadcast those harsh conditions they are facing there, Kira.
All right. Well, how do you see this all playing out, Alex?
Well, it's really unclear. If Judge Boasberg were to come back and say the administration violated my order, it really becomes up to him. How does he hold them to account? There's a range of potential actions he could take. He could issue sanctions.
And then, despite that explicit judicial order, planes carrying more than 200 people took off anyway. Flights that removed people to El Salvador in direct defiance of what the court had ordered. When that happened, when the planes took off in clear violation of his order, Boasberg issued the ruling we are discussing today. He found that the administration had shown willful disregard for his instructions. He gave officials 1 week to purge the contempt, either by asserting custody over the deported individuals held in a major prison in El Salvador, or by proposing some other way to bring the government into compliance. And he warned that if those options were not pursued, the officials responsible could be found in criminal contempt of court, a step that could lead to imprisonment. That sequence, court order, deliberate violation, willful disregard finding, 1 week deadline, criminal contempt warning, is the most direct judicial confrontation with executive defiance that any federal court has produced in the current term. Now let us talk about the willful disregard language, and why it is legally significant. Because judges do not use that phrase carelessly. Willful disregard in the contempt context means the court has found that the violation of its order was not accidental, not the result of misunderstanding, not the product of administrative delay or processing error. It means the court has determined that the people responsible knew about the order and chose to violate it anyway. That determination is essential to the criminal contempt analysis because criminal contempt requires proof of willful violation, of knowing and intentional defiance of a court order. By finding willful disregard in his ruling, Boasberg was essentially making the factual finding that is prerequisite to criminal contempt proceedings. He was saying, based on what I have seen, these officials knew what my order said and chose to defy it. And that finding, coming from the judge in the case, on the record in a formal ruling, is exactly the kind of documented judicial determination that criminal contempt proceedings would need to establish the willfulness element. Boasberg did not just threaten contempt in the abstract. He documented the factual basis for it in language that is legally precise and legally consequential. Now let us talk about the 1-week deadline and what the purge requirement actually means. Because the specific remedy Boasberg offered, purging the contempt by asserting custody over the deported individuals or proposing an alternative, is significant for what it reveals about the judge's theory of what compliance actually requires. When a court says you must purge a contempt finding, it is saying the violation occurred, it is documented, and the only way to address it is to actually remedy the harm caused by the violation. In this case, the harm was the deportation of more than 200 people in defiance of a court order. The purging remedy requires the government to actually address that harm, to reassert legal custody over people who were removed in violation of the court's order. That is not a procedural formality. That is a substantive requirement to undo, or at least address, the actual consequences of the defiance. And the difficulty of complying with that requirement, the practical challenge of reasserting custody over people who are now in a prison in El Salvador in a foreign country under the authority of a foreign government, is part of what makes the situation so complicated and so potentially consequential. The administration created a fact on the ground by deporting people in violation of the court's order. The court is now demanding that the administration address those facts on the ground. And the difficulty of addressing them is itself a form of consequence for the original defiance. Let us also talk about the personal liability dimension of Boasberg's ruling and what it means for the people who made the decisions that led to the deportations. Because the ruling's specific focus on individual officials rather than just on agencies, or the administration as a collective, is one of its most significant and most legally consequential features. When a judge warns that criminal contempt could lead to imprisonment, the imprisonment is not of the Department of Homeland Security as an institution. It is of the specific human beings who made the specific decisions that resulted in the violation of the court's order. The people who authorized the deportation flights despite the court order. The people who knew about the order and chose to proceed anyway. The people whose names appear in the chain of command between the policy direction and the actual planes that took off. Those specific individuals, if criminal contempt proceedings are initiated, and if the willfulness finding is sustained, face the prospect of personal criminal exposure for following the administration's immigration enforcement instructions. And that personal exposure, the possibility of being individually arrested and imprisoned for complying with the president's orders, creates a specific and genuinely difficult situation for the officials involved. They are being asked to choose between loyalty to the president and compliance with the court. And the judge has made clear that the cost of choosing loyalty over compliance can be personal imprisonment. Now let us think about the broader war with the court's context in which this ruling is happening. Because the Boasberg contempt warning did not occur in isolation. It occurred in the specific context of an administration that has been escalating its conflict with the judiciary throughout Trump's second term. We have covered extensively in this series the pattern of Trump publicly attacking judges who rule against him, calling justices fools and lapdogs after the tariff ruling. the Chief Justice responding that the attacks are dangerous and must stop. Justice Gorsuch asserting loyalty to the Constitution rather than to the appointing president. Justice Jackson warning that the attacks appear designed to intimidate the judiciary. But there is another dimension to the war with the courts that is separate from the public rhetoric attacks, and that is more operationally alarming. The arrest of Wisconsin Judge Hannah Dugan, a state judge who was arrested by federal immigration agents in circumstances that generated enormous controversy about whether the administration was targeting judges, is part of the same pattern. The administration's rhetoric characterizing judges who rule against immigration enforcement as obstacles to be attacked rather than legal authorities to be respected. The pattern of defying court orders on immigration and then challenging courts to enforce them. All of that context makes the Boasberg contempt warning not just a single ruling in a single case, but a flashpoint in a systematic conflict between the executive and judicial branches over who has final authority over immigration enforcement. Let us also talk about the specific case, the Alien Enemies Act deportations to El Salvador, and why it became such a significant flashpoint in the judiciary-executive conflict. The Alien Enemies Act of 1798 is a wartime law that gives a president extraordinary powers to detain and remove non-citizen nationals of an enemy country during declared wars or invasions. The Trump administration's use of it for peacetime immigration enforcement, characterizing gang membership in the border situation as an invasion that activates a wartime statute, is a legal theory that courts have been skeptical of. The Supreme Court's emergency orders blocking deportations under the Alien Enemies Act reflect that skepticism. And Boasberg's order specifically prohibiting the use of the statute was grounded in the same legal analysis that the wartime statute does not authorize what the administration is trying to do with it in the current situation. The deportation of more than 200 people to El Salvador, despite that specific court order, was not just a legal violation. It was a statement that the administration is prepared to proceed with its immigration enforcement agenda, regardless of what courts say about the legal authority being claimed. That statement, the planes taking off in defiance of the court order, provoked exactly the response that Boasberg's ruling represents. A court that had been defied decided to make clear that defiance of its orders carries real personal consequences for the people responsible. And let us think about what the contempt warning means for the officials in Trump's chain of command, who are now facing the choice between following the president's orders and avoiding personal legal exposure. This is the most genuinely difficult and most genuinely novel situation that the war with the courts dynamic has produced so far in the second term. Previous conflicts between courts and the administration have been largely institutional. Courts blocking policies, administration appealing, the legal process grinding forward. The Boasberg ruling makes the conflict personal. Specific officials who followed specific instructions that resulted in specific violations of a specific court order are now facing specific consequences that could include imprisonment. That personalization of consequence from institutional to individual changes the calculus for everyone in the chain of command. A White House aide or a DHS official who is asked to implement a policy in defiance of a court order now has to weigh not just the institutional consequences, but the personal consequences. Not just whether the policy is legally sustainable, but whether carrying it out could result in them being personally named in a criminal contempt proceeding. That is a genuinely new element in the relationship between executive officials and judicial orders. And it has the potential to change the behavior of individual officials in ways that purely institutional consequences do not. Now, let us also talk about what compliance with the court's one-week deadline would actually require, and what failure to comply would mean, because the practical stakes of the deadline are themselves significant. Compliance requires the administration to assert custody over the deported individuals in El Salvador, or propose an alternative compliance mechanism. That is an extraordinarily difficult practical requirement. The people were deported to a foreign country, to a facility controlled by a foreign government. Getting them back, or even establishing legal custody arrangements that would satisfy the court's compliance standard requires diplomatic engagement with El Salvador, legal arrangements across international jurisdictions, and practical logistics that cannot be accomplished instantly, even if the political will to comply is present. If the administration cannot or does not comply with the deadline, Boasberg has made clear that criminal contempt proceedings follow. And criminal contempt proceedings against senior executive officials would represent a constitutional confrontation that has no real precedent in modern American history. A federal judge initiating criminal proceedings against named members of the executive branch for defying a court order in an immigration case is something that would generate enormous institutional and constitutional implications regardless of its specific legal outcome. The willful disregard finding is legally precise and legally consequential. It represents the court's documented determination that the violation was deliberate. Boasberg did not just find that the court's order was violated. He found that it was willfully disregarded, that the officials responsible knew about the order and chose to violate it anyway. That finding is the factual prerequisite for criminal contempt, and it is now on the record in a formal judicial ruling. Its legal significance is specific. It documents the element of willfulness that criminal contempt requires, and it establishes the factual basis for any subsequent contempt proceedings that Boasberg might initiate if the one-week deadline is not met. The personal liability dimension is genuinely novel and genuinely consequential for Trump's inner circle. Previous judicial executive confrontations have been largely institutional. This ruling makes the consequences personal. Specific individuals who made specific decisions are now facing the prospect of specific criminal exposure, potential imprisonment for following the administration's immigration enforcement instructions in defiance of a court order. That personalization creates a specific and difficult choice for everyone in the chain of command between loyalty to the president and compliance with the courts. And it changes the calculus for individual officials in ways that purely institutional consequences do not. The ruling is a flashpoint in a broader systematic conflict between the administration and the judiciary. And it cannot be understood in isolation from that context. The pattern of attacking judges, defying court orders on immigration, characterizing judicial constraints as obstacles to be overcome. All of that context makes the Boasberg contempt warning part of a larger story about the relationship between the executive and judicial branches under Trump's second term. The ruling represents a court that has had enough of being defied and is willing to use the most serious tools available to it to enforce its orders. Whether that willingness produces actual compliance or further escalation is the question that will shape the next chapter of this story. The choice that the ruling forces on Trump's officials between following his orders and avoiding personal legal exposure is one of the most significant accountability mechanisms the judiciary has deployed in the current term. Presidential immunity protects Trump personally from the consequences of ordering defiance of court orders. It does not protect the officials who carry out those orders. By making individual officials personally responsible for compliance or non-compliance with his orders, the court is creating a structural incentive for executive branch actors to push back against instructions that would expose them to personal criminal liability. Whether that structural incentive actually changes behavior, whether officials will refuse to carry out instructions that would defy court orders out of fear of personal contempt exposure, is genuinely uncertain. But the possibility itself represents a form of judicial leverage over executive branch behavior that has not been this clearly articulated in any previous confrontation between the courts and a modern American administration. And here's the broader constitutional significance of Boasberg's ruling for the future of executive-judicial relations in the American system. The question of how courts enforce their orders against an executive branch that decides to defy them is one of the oldest and most difficult questions in American constitutional law. Courts have no army. They have no police force. They depend on the executive branch to enforce their orders. which creates an obvious structural problem when the executive branch itself is the party defying those orders. The historical examples of executive defiance of courts have generally resolved in one of three ways. The executive branch backs down under political pressure. The issue becomes moot because the underlying policy goal is achieved by other means, or the confrontation escalates to a full constitutional crisis that forces some kind of political resolution. Boasberg's contempt warning is an attempt to create a fourth option: personal criminal exposure for the individuals responsible for the defiance that creates a specific and personal incentive for compliance that institutional consequences alone may not provide. Whether that fourth option is effective in practice depends on whether the threat of personal criminal exposure is credible enough and severe enough to actually change the behavior of officials who are caught between the president's instructions and the court's orders. The one-week deadline will begin to answer that question, and the answer will shape how courts think about enforcing their orders against executive defiance for years to come. Now, let us also think about what the El Salvador deportation context specifically adds to the significance of this ruling. The people who were deported to El Salvador, more than 200 individuals removed in defiance of a court order, are not abstractions. They are real human beings who are now in a foreign prison in a country that is not their own, having been removed through a legal process that a federal court specifically prohibited. Whatever the legal and political arguments about immigration enforcement, the human reality of 200 people in an El Salvador facility as a result of a deportation that a court explicitly ordered not to happen is the most concrete expression of what executive defiance of judicial orders actually means in practice. Those are not numbers, those are people. And the court's insistence that the administration either bring them back or establish custody arrangements is ultimately an insistence that the human consequences of defying a court order cannot simply be left in place and ignored. That the practical effects of violating a court order on actual human beings cannot be shielded from judicial remedy by the executive's claim that the policy was more important than the order. Boasberg's ruling is asserting the principle that court orders exist to protect real people from real harm, and that when the executive defies those orders and causes real harm to real people, the courts have both the authority and the obligation to demand that the harm be addressed. The pattern of escalation in the Trump administration's conflict with the judiciary, from hostile rhetoric to defiance of specific orders to the arrest of a state judge, and the court's escalating responses, from blocking policies to issuing emergency orders to threatening criminal contempt of individual officials, is approaching a point where the escalation itself becomes the story. At some point, the question is not whether the administration will comply with this specific order or whether this specific contempt warning will produce this specific sanction. The question is whether the executive and judicial branches can continue to function as a constitutional system in the face of escalation that neither side appears willing to de-escalate. Courts that cannot enforce their orders against an executive that defies them lose their authority as institutions. An executive that cannot carry out his policies because courts keep blocking them faces its own institutional crisis. The constitutional design assumes cooperation, assumes that both branches will operate within the constitutional framework rather than trying to overwhelm each other. When that assumption breaks down, when the conflict reaches the level of contempt warnings and arrest threats and judges being arrested by immigration agents, the system is in a kind of constitutional stress that it was not designed to sustain indefinitely. What resolves that stress? Elections, political shifts, voluntary de-escalation, or further confrontation that forces a definitive resolution one way or another is the most important open question in American constitutional democracy right now. And Boasberg's ruling is one of the clearest signals yet that the stress is approaching a level that demands resolution. Stay with us because the next chapter of this story is coming faster than anyone expected.